If understanding your rights clearly, instead of just vaguely, is something that matters to you, I'd really appreciate it if you hit subscribe before you go, because that's exactly what this channel is built around, one real, specific legal topic at a time, explained in plain language without the unnecessary complexity. It genuinely helps more than you'd think, mostly because it tells me this kind of plain language legal content is actually reaching the people who need it, which is the entire point of doing this in the first place. All right, that's the ask. Let's keep going. You are running, not from guilt, not from anything you've actually done. Maybe you made a bad call earlier in the night. Maybe something got out of hand. Maybe the situation escalated faster than you could process it. Or maybe you were just in the wrong place at the wrong time when something happened nearby. Whatever the reason, you are running, and behind you there are officers, and ahead of you there is your front door, your own front door, the place where your keys are, where your couch is, where your life is, and your hand is already reaching for the lock. And the second you get inside and pull that door shut behind you, a question is forming that almost nobody can answer correctly without having thought about it in advance. A question the law has answered in a specific, nuanced, genuinely complicated way, and the answer affects everything about what happens next. Can they follow you in? Does running home give them the right to come through that door without a warrant? Does a misdemeanor, not a felony, not a violent crime, a misdemeanor, automatically give them that power? The answer is no, not automatically. And the story of why, and the specific conditions that determine when the answer might shift, is one of the most important things you could understand about your rights in this country, because it sits at the exact intersection of two of the most protected things in the legal framework that governs your life, your home and your person, and what happens when law enforcement tries to reach both of them at once, through a single act of following you inside. Before we walk through exactly how this works, if understanding your actual rights before you need them, specifically instead of guessing under pressure when the stakes are real, is something that matters to you, subscribe right now, because that's exactly the kind of preparation this is built to give you. And a quick note before we get into it, this is legal education and general commentary, not specific legal advice for your particular situation, and while the principles we're going to cover are rooted in Supreme Court decisions that apply across the country, specific applications can vary by state and by the exact facts involved. With that said, let's get into it. Let's start at the foundation, the thing everything else in this conversation is built on, because without it, the rest doesn't make the right kind of sense. The Fourth Amendment to the United States Constitution protects against unreasonable searches and seizures. You've probably heard that phrase. What you may not have heard explained clearly is that the word unreasonable doesn't mean the same thing in every location. It's interesting, honestly, how often variations of this general subject keep coming up, across completely different specific situations, over and over. I think that's because the underlying pattern is more universal than people initially assume. A moment of pressure, a question that sounds simple but carries real legal weight, an instinct to just go along with things smoothly rather than pause and think it through. That basic shape shows up across an enormous range of otherwise completely different situations, which is exactly why understanding the underlying pattern, rather than just memorizing one specific scenario, ends up being so useful. Once you see the shape clearly in one context, you start recognizing it everywhere else too. All right, let's dig into today's specific version of that pattern. The standard shifts, depending on where you are, when the government tries to intrude on your person or your belongings. And it shifts dramatically, when you step inside a home. Courts have consistently described the home as the place where Fourth Amendment protection reaches its absolute peak. Not your car, not your backyard in every situation, not a hotel room, not a workplace, not a public phone booth. Your home. The place where the framers of this country's founding documents were most deliberate, most specific, most insistent about building a wall between you and arbitrary government intrusion. The reason that wall was built the way it was has everything to do with history that predates this country's existence. The experience that shaped the founders' thinking about home searches was a specific, visceral one. Officials with general writs of assistance walking into homes whenever they felt like it, for whatever reason they chose, without any specific authorization, without any prior approval from a neutral authority, simply because they had the power to do it. The Fourth Amendment was written specifically to prevent that. A warrant requirement exists not as a bureaucratic inconvenience, but as a structural guarantee that a neutral judge, someone with no stake in the outcome, someone not involved in the investigation, has reviewed the evidence, found it sufficient, and specifically authorized the intrusion. And nowhere is that requirement more absolute, more protected, more resistant to exception than at the threshold of a home. That's the baseline. That's the wall. And now let's talk about what happens when someone is chasing you toward it. The specific legal question of whether police can follow a fleeing suspect into a home without a warrant has been percolating through courts for decades, and it came to a genuine head in a way that matters enormously to anyone trying to understand this area of law. For a long time, the prevailing assumption in law enforcement, and honestly, among most people who thought about it at all, was that hot pursuit was hot pursuit. If you're running from police and you run through your front door, they follow you. End of story. Because the chase was already underway, and a door doesn't stop a lawful pursuit. That felt intuitive. It felt practical. It was also, as it turns out, not quite accurate as a blanket rule, particularly when the underlying offense being pursued is a misdemeanor rather than a felony. The case that changed the conversation in a significant and direct way came down from the Supreme Court relatively recently, and it involved exactly this scenario. Not a violent felony, not an emergency situation with weapons and threats and people's lives at stake, but a misdemeanor. Specifically, the case of Lang versus California, decided in 2021, addressed the question of whether the pursuit of a misdemeanor suspect always justifies warrantless entry into a home, and the court's answer was a clear, deliberate, unanimous no. Not a close call, not a divided bench splitting hairs. Unanimous. The hot pursuit of a misdemeanor suspect does not categorically, automatically, by default, justify entering that person's home without a warrant. Each situation requires an examination of its specific circumstances, an evaluation of whether there was a genuine emergency, a genuine immediate threat, a genuine exigency that made getting a warrant before entry impossible or unreasonable. The blanket rule that pursuit always equals automatic entry into a home does not exist for misdemeanors. Let's slow down on why that matters, because it's worth really sitting with for a moment. What the court was saying is not that police can never follow a misdemeanor suspect into a home. What it was saying is that they cannot do it automatically, without any additional justification beyond the fact that a pursuit was underway. The word categorically is doing serious work in the court's reasoning. Categorical means across the board, regardless of circumstances, as a rule, and the court said that category does not exist here. Instead, what matters is whether the specific facts of the specific situation actually created a genuine emergency, a real, concrete, specific reason why waiting for a warrant was not a viable option. And importantly, not every misdemeanor pursuit involves that kind of emergency. In fact, most don't. Now let's talk about what exigent circumstances actually means in this context, because this is the concept sitting at the heart of every legitimate exception to the warrant requirement for home entry, and it's worth understanding with real precision rather than just as a general concept. Exigent circumstances are circumstances that are truly urgent, circumstances where the time required to obtain a warrant would actually result in meaningful harm, someone being hurt, evidence being destroyed, a suspect escaping in a way that genuinely couldn't be prevented otherwise. Courts have recognized several categories of situations that can qualify: the risk of immediate violence to someone inside or nearby, the imminent destruction of evidence, the immediate escape of a suspect in a way that would make them genuinely unreachable once inside, a medical emergency requiring instant response. These are real, specific, high-stakes situations that courts have acknowledged can, in some circumstances, justify crossing the threshold of a home without the prior judicial authorization a warrant provides. But here is what doesn't automatically qualify: the simple fact that someone ran, the simple fact that you were being chased, the simple fact that you went inside your own home while pursuit was ongoing. None of those things, standing alone, without additional specific facts suggesting an actual emergency, automatically creates exigent circumstances. The court in Lang was explicit about this. Running home, by itself, doesn't establish an emergency. It establishes that someone went home, which is not the same thing, and treating them as equivalent would effectively eliminate the warrant requirement for home entry anytime any kind of pursuit was underway, regardless of how minor the underlying offense was or how minimal the actual risk of any genuine harm was. Let's talk about the difference between felony pursuit and misdemeanor pursuit, because the law does treat them somewhat differently, and it's worth being clear about that distinction, even as we focus specifically on what happens with misdemeanors. For felonies, particularly violent ones, courts have historically given more room to law enforcement entering a home in hot pursuit, because the calculus of potential harm is different. A violent felony suspect fleeing into a home involves a genuinely higher potential for danger, to other occupants of the home, to officers attempting to maintain a perimeter, to the public more broadly, and the courts have generally reflected that in how they balance the warrant requirement against the practical realities of a serious active pursuit. Even there, it's not an unlimited automatic exception, but the balance tips differently than it does with a misdemeanor. For misdemeanors, the category the Lang case spoke to directly, the balance tips significantly back toward the warrant requirement. Misdemeanors, by definition, are lesser offenses. They don't carry the same presumption of ongoing violence, the same level of threat, the same urgency that a serious felony does. And that matters, because if the justification for crossing the threshold of someone's home without a warrant is an emergency, then the severity of the underlying offense is directly relevant to whether a genuine emergency actually existed. A person who allegedly ran a red light and then ran inside their house before officers could stop them is in an entirely different factual situation from a person who just committed armed robbery and ran into a house while still potentially armed. The Lang court understood this distinction and built it directly into the analysis. Let's talk about what the law expects officers to do in a misdemeanor situation when there isn't a clear, genuine exigency. The answer is not actually complicated in principle, even if it sometimes feels that way in practice. Officers are expected to secure the perimeter if there's a genuine concern about the person fleeing permanently, and then go get a warrant. That's the process. That's what the warrant requirement is there to mandate. A neutral judge reviews the situation, determines whether there's probable cause, and authorizes entry. Yes, this takes time. Yes, it may be inconvenient. But the inconvenience of the process is not a legal justification for bypassing the process, and the courts have said so with considerable clarity. The fact that it would have been faster to just go in doesn't make it legal to just go in, particularly when the offense being pursued doesn't carry with it any strong presumption of ongoing emergency. Now let's get practical, because understanding the legal framework is important, and so is understanding what it means for you in a real moment. One that actually happens to real people, in situations that are far less dramatic and far less clear-cut than the case studies that make it into Supreme Court opinions. Let's say you've been out, something happened, you're not certain whether you're actually being pursued or whether officers are in the vicinity for an unrelated reason, and you get inside your home. What does the law say about your position from inside that door? If there is no warrant, and officers did not have a specific, concrete exigency, a genuine emergency, a specific immediate threat, actual evidence about to be destroyed right now, then your being inside your home carries the full weight of Fourth Amendment protection. Officers cannot simply demand entry. They cannot simply announce that they're coming in and expect the law to back them up without more. The fact that a pursuit was underway for a misdemeanor is not, after Lang, automatically enough. You are inside your home, and your home carries the strongest protection the legal system offers you. What you do from that point matters. Staying calm matters. Not opening the door based on demands alone matters. And crucially, not making statements or engaging in ways that complicate your situation matters. If officers announce themselves and ask you to come out or to open the door, the question you want answered first, the question that determines everything about the legal shape of what happens next, is whether they have a warrant. Through the door, calmly, that's what you ask. Because the answer determines whether you are dealing with a situation governed by your right to remain protected inside your home, or a situation where judicial authorization has already been obtained, and the framework shifts accordingly. Let's talk about what happens when officers claim exigent circumstances after the fact, meaning they enter without a warrant and then explain the entry later by pointing to an emergency they say existed. This happens, and it matters, because the burden of justifying a warrantless entry into a home falls on law enforcement, not on you. Officers who enter without a warrant bear the responsibility of demonstrating that the circumstances genuinely required it, that there was a real, specific, immediate threat that made obtaining a warrant before entry genuinely unreasonable. Courts look at these justifications after the fact, in suppression hearings, where evidence obtained through an illegal search or seizure can potentially be excluded from use against you, and where the officer's claimed reasons for the warrantless entry get examined by a judge without the pressure and urgency of the moment in which the decision was made. This is important because it means that the legal fight over whether entry was justified often happens after the fact, not at the door in real time. You, standing inside your home in that moment, are not the one who wins or loses the legal argument in the moment it's happening. What you are doing in that moment is preserving the factual record by not consenting to entry, by making clear through the door that you do not consent, by not doing anything that could be interpreted as having invited officers inside voluntarily. That gives an attorney the best possible foundation to make that argument later, in the setting where it can actually be made properly, which is a courtroom, not a doorstep. Let's talk about consent specifically in this scenario, because consent is where things can quietly go wrong for people who understand the general principle but miss the practical application. Even in a pursuit situation, even when officers are at your door specifically because they were following you, the rules around consent remain the same. If you open the door and say nothing, if you open the door and step back in a way that suggests you're letting them in, if you say anything that can be interpreted as agreeing to their entry, any of those things can and do get treated by courts as consent, which eliminates the need for officers to justify the entry on any other grounds at all. The case goes from being about whether there was a valid warrant or valid exigency to being about whether you said yes, even quietly, even inadvertently, even without realizing you were saying it. This is why the words you use and don't use matter so much in the moments immediately after you're inside your door with officers on the other side. I don't consent to entry through the door, stated clearly and calmly, does something specific and important. It removes any ambiguity about whether what follows was agreed to. It doesn't guarantee officers won't enter. It doesn't make the door physically stronger. What it does is create a clear factual record that whatever happened next was not something you agreed to, which is exactly the foundation an attorney needs to challenge the legality of the entry later if the situation ever gets to that point. Let's talk about the scenario where there are multiple officers involved and they approach the situation differently. One of them claiming immediate exigency, while another is trying to reach a supervisor for guidance, or where some are asking for consent while others are treating entry as already authorized. This kind of confusion happens in real situations, and it can be disorienting to navigate from inside your home when voices are coming from multiple directions and the situation feels chaotic and urgent. The guidance doesn't change based on the number of officers or the differing approaches they're taking. The question is still the same: do they have a warrant? If yes, ask to see it, read it carefully, understand what it authorizes, and comply with its specific scope, while stating clearly that you don't consent to anything beyond that scope. If no, you do not consent to entry, you're stating that clearly, and you're not opening the door to resolve the chaos on the other side of it. The chaos on the other side is not your legal problem to solve. What's on your side of the door is the only space you're responsible for in this moment. Let's talk about something that comes up specifically in pursuit scenarios that doesn't come up as often in ordinary knock-and-talk situations. The question of whether injuries, weapons, or threats visible through the door or claimed by officers during the pursuit change the analysis. They can. If officers are pursuing someone who they observed commit a violent act, or if there's a specific, credible reason to believe that someone inside the home is in immediate danger, or that a weapon is about to be used, those facts change the exigency calculation in ways that courts take seriously. An emergency is an emergency, and the law recognizes that genuine emergencies sometimes don't accommodate the time required to get a warrant. But the word genuine is carrying a lot of weight in that sentence, and courts scrutinize it carefully. An emergency claimed by officers after the fact, without contemporaneous evidence of what actually made waiting for a warrant impossible, is a weaker justification than one that's clearly documented in real time. The severity and credibility of the claimed emergency matter. A person who ran from officers after allegedly jaywalking and is safely inside their home with no weapons, no other persons at risk, and no ongoing danger. That situation does not present the kind of emergency that the exigent circumstances exception was built to address. A person who fled after discharging a weapon in a crowded area and ran inside a home with a victim still in danger. That's a different analysis entirely, and pretending otherwise would be inaccurate. Let's talk about what happens if you are inside your home and officers begin entering without a warrant and without your consent, because this is the moment where the stakes are highest and the right instinct is the most counterintuitive for a lot of people. Physical resistance is not the right move. I want to be absolutely clear about this because it matters both for your safety and for your legal position. Even if an entry is unlawful, physically resisting officers attempting to enter creates an immediate, separate, additional legal problem. Potential charges of resisting arrest or obstruction that can exist independently of whether the underlying entry was legal or not, and that complicates every other aspect of your situation in ways that are very difficult to walk back later. In most jurisdictions, the legal framework does not give you the right to physically resist even an unlawful police entry, and testing that framework in the moment is not where this fight belongs. Where it belongs is in a courtroom, with an attorney, in a suppression hearing, where a judge examines whether the entry was lawful, whether any evidence obtained through it was the product of a constitutional violation, and whether that evidence should be excluded from use against you. That's the arena where unlawful home entries get challenged effectively. Not the doorway, not your living room. A federal or state courtroom months later, with proper representation, in a process built specifically to examine exactly this kind of question. So what do you do if they're coming in? You state clearly, once more, that you do not consent. You do not physically interfere. You stay calm. You observe what's happening, who's there, what they're doing, what they're saying, what they're looking at and touching, with as much attention as you can manage, given the circumstances. And the moment it's over, you begin documenting everything you can recall, every detail, every name and badge number you caught, every statement made, every item touched or moved, every second of the timeline you can reconstruct, because that documentation is the raw material an attorney needs to examine whether what just happened was lawful and what your options look like moving forward. Let's talk about the period immediately after officers leave, whether they left because they confirmed you were inside and chose to step back and pursue other options, or because the encounter resolved in some other way. This window is critically important, and people routinely underutilize it because the adrenaline of what just happened leaves them either relieved that it's over or too shaken to think clearly about the next step. Write down everything immediately. Everything. What time it started. What time it ended. How many officers. What they said. As close to word for word as you can manage. What you said. Whether you stated that you didn't consent and how they responded to that. Whether any warrant was produced and what it said. Whether any property was touched, moved, or taken. Whether any threats were made or pressure was applied. Whether there was any claim of exigency and exactly how it was characterized. Voice memos work. Notes in your phone work. Whatever format you can manage fastest while the details are still sharp in your memory, use it. Memory degrades faster than people expect, especially after a high-stress encounter, and the version of events you reconstruct 3 weeks later from a general impression is significantly less useful than the version you capture in the first hour, while the specifics are still clear. Let's talk about getting an attorney involved, because this is where the general advice in this video necessarily has to give way to the specific guidance that only a professional familiar with your particular situation and your particular state can provide. If you've been through a pursuit situation that ended with officers at or inside your home, whether or not you've been charged with anything, whether or not any evidence was seized, the right move is to speak with an attorney before you speak to law enforcement again about anything related to the situation. Not because you're guilty, not because you have something to hide, because the legal framework surrounding what just happened, the questions of whether the pursuit was lawful, whether the entry was justified, whether any evidence collected during it can be used against you, and what your options look like, is genuinely complex. And navigating it without guidance is significantly more difficult than navigating it with someone whose entire professional existence is built around exactly these questions. The Fifth Amendment right not to incriminate yourself doesn't expire the moment the initial encounter is over. It continues to exist in every subsequent conversation law enforcement might want to have with you, and exercising it by declining to answer questions until you've had the chance to speak with an attorney is not a confession, and not an admission, and not anything at all except the smart, legally protected choice that the Constitution specifically guarantees you the right to make. Let's go deeper into the Lang decision specifically, because it's worth understanding what the court actually said, and why. Not just as a headline, but as a piece of legal reasoning that illuminates how this area of law works, and why it matters, beyond just this one specific case. The facts of Lang versus California involved a man named Arthur Lang who was driving with his music loud and honking his horn, a minor violation, when a highway patrol officer began following him with lights activated. Lang drove into his garage and the garage door began closing. The officer put his foot under the closing door to stop it and followed Lang inside. Lang was ultimately charged with driving under the influence based on what the officer observed inside the garage. The question before the Supreme Court was whether the officer's warrantless entry was justified by hot pursuit of a misdemeanor suspect. The court, in an opinion written by Justice Kagan, said no, or more precisely, said that hot pursuit of a misdemeanor suspect does not automatically and categorically justify warrantless home entry. The court's reasoning drew heavily on the history of the Fourth Amendment's special protection for the home, on the principle that the warrant requirement is the rule and exceptions are narrow, and on the practical reality that most misdemeanor pursuits simply don't involve the kind of urgent, life-or-death emergency that would justify bypassing the judicial authorization process entirely. The court specifically noted that the flight of a misdemeanor suspect does not by itself demonstrate an emergency, and that officers in such situations generally have other options, securing the perimeter, calling for backup, seeking a warrant, that don't require crossing the threshold of a home without judicial authorization. Justice Kavanaugh, in a concurrence, suggested that flight from police might itself sometimes create an exigency by suggesting the suspect intends to destroy evidence or escape permanently, but even he agreed that the analysis had to be specific and circumstantial rather than categorical. There was no vote on the court for the proposition that misdemeanor pursuit automatically equals warrantless home entry. Not one. What the court left open, and what remains genuinely uncertain in the ongoing development of this area of law, is exactly how specific facts in specific situations get evaluated. What level of flight suggests an emergency? What types of misdemeanors carry enough weight to shift the analysis? How courts should handle situations where the officer's belief about the threat was reasonable, even if it turned out to be mistaken. These are questions that will continue to be worked out in cases decided after Lang, in state courts and federal courts, in situations that arise from the specific facts of people's actual lives. And that ongoing development is part of why having an attorney who stays current in this area is so important if you ever find yourself in a situation where these questions are actually your questions, not just academic exercises. Let's talk about what the Lang decision means for law enforcement practice, because understanding how officers are supposed to approach these situations after Lang helps you understand what's expected of them and what deviation from that expectation might mean for how your specific situation gets analyzed. After Lang's, officers pursuing misdemeanor suspects who go inside a home are supposed to stop at the threshold and evaluate, is there a specific, concrete, immediate emergency that makes waiting for a warrant genuinely impossible or genuinely dangerous? Not is this inconvenient, not is this going to take time, not is the suspect going to have a few hours to get their bearings before we can come back, but is there an actual emergency, right now, that the warrant process cannot accommodate without real, concrete harm resulting? If the answer is no, they are supposed to seek a warrant. Perimeter security while a warrant is obtained is an established part of the operational toolkit, and the fact that it takes time is not a legal emergency. Time and inconvenience have never been treated as exigent circumstances by any serious reading of Fourth Amendment jurisprudence. Officers who bypass this evaluation and simply follow a misdemeanor suspect inside without a warrant are taking a legal risk, the specific risk that the evidence obtained inside will be subject to suppression and that the entire case built on what was found or observed inside will be challengeable as the fruit of an unconstitutional search. The exclusionary rule, which prevents illegally obtained evidence from being used against a defendant, is a direct and powerful consequence of unconstitutional home entries, and it is the mechanism that makes the warrant requirement something more than a polite suggestion. Let's talk about something that comes up in discussions of this area and that deserves direct engagement. The argument that people who haven't done anything wrong don't need to worry about any of this. That the only people who care about warrant requirements and warrantless entries are people who have something to hide. This argument is both logically flawed and historically demonstrably wrong, and it's worth taking a moment to push back on it clearly. The warrant requirement doesn't exist to protect guilty people from accountability. It exists to ensure that a neutral, independent authority, not the officer on the scene making a quick judgment call in a high-pressure moment, determines whether intrusion into the most protected space in a person's life is actually justified by real, specific evidence. The history of every country that has abandoned this kind of structural protection between the government and the citizen's home is not a history anyone should want to replicate. The protection doesn't become valuable only when you've done something wrong. It's valuable because the question of whether you've done something wrong and the question of whether the government has enough evidence to justify invading your home should be answered by someone with no stake in the outcome before that invasion happens. That's the principle. That's why it matters. And it matters for everyone, precisely because none of us can predict with confidence which of us is going to be on the wrong end of a situation we didn't create or anticipate. Let's talk about another angle of this that's worth understanding. What happens when the person who was being pursued wasn't the homeowner? What if you're inside your home, you had nothing to do with any pursuit, and officers are at your door because they believe a third person they were chasing ran onto your property or into your building? Does their authority to pursue that third person extend to your home? The answer here is genuinely more complicated and depends heavily on specific facts. If officers have probable cause to believe the person they were pursuing is currently inside your specific dwelling, and there are genuine exigent circumstances, real, specific, immediate ones, not just the fact that pursuit was ongoing, there may be legal justification for entry, even though the home isn't the pursued person's own. But the warrant requirement doesn't disappear simply because the person inside isn't the homeowner. Courts have consistently been cautious about allowing pursuit of a third party to become a blanket justification for searching or entering the homes of innocent people who had nothing to do with the underlying situation. If you're the homeowner and officers are at your door because they think someone else ran inside, the same guidance applies. Ask whether there's a warrant, state clearly that you don't consent to entry without one, and let the question of whether there was genuine exigency be answered by a court afterward. Let's talk about the specific situation of someone who lives in an apartment building rather than a standalone home, because there are layers here that are worth understanding separately. The protection we've been discussing throughout this conversation applies to your specific unit, the actual dwelling space you occupy, and courts have consistently treated the threshold of that unit as carrying the same protection as the front door of a standalone home. Shared hallways, building lobbies, parking structures, common areas, these receive less protection because other residents and the building itself have access to them, and courts have generally found that entry into shared common areas doesn't trigger the same warrant requirements that entry into a specific unit does. This means that officers pursuing someone through a shared hallway are in a different legal position than officers pursuing that same person through the door of their specific apartment. The hallway may not require the same justification to be present in. The apartment door is another matter entirely. Understanding this distinction is particularly useful if you live in a building and an incident happens in a common area. The question of whether officers being present in that shared space was itself a constitutional issue is different from the question of what authority they have once they reach your specific door. Let's talk about cell phones, because in the modern version of any of these scenarios, your phone is almost certainly involved, and what you do with it in the moments during and immediately after an encounter like this matters in ways worth thinking about in advance. Do not, under any circumstances, delete anything from your phone in the belief that you're protecting yourself. In many situations, deleting data related to a police investigation, even data on your personal device, can itself be treated as obstruction or destruction of evidence, and the attempt to conceal can sometimes be treated more harshly than the underlying thing being concealed. If officers don't have a warrant to search your phone, and they generally need one, thanks to Riley versus California, the 2014 Supreme Court decision that established that cell phones require separate warrant authorization to search, you are not required to unlock your phone, provide your passcode, or give access to your device simply because they ask. I don't consent to a search of my phone applies here the same way it applies to your home, and the warrant requirement for electronic devices is one of the more robust protections that remains in place, even in situations where other aspects of the Fourth Amendment's application have been eroded. If you used your phone to film any part of an encounter, which you're generally allowed to do in public-facing situations and often in your own home, that footage is potentially valuable, and the instinct to immediately share it widely or post it publicly is one worth resisting, at least until you've spoken with an attorney who can advise you on how best to preserve and use it in a way that serves your interests, rather than complicating them. Let's talk about the gap between what the law says and what actually happens in practice in these situations, because pretending that legal rights automatically translate into smooth, orderly experiences at the moment they matter most would be misleading and ultimately unhelpful. The reality is that even if officers enter your home in a way that is ultimately found to be unconstitutional, that finding happens later, in a court, after the entry has already occurred. The law does not have a mechanism that physically prevents an unlawful home entry in the moment it's happening. What the law has is a set of consequences that follow from unlawful entries: evidence suppression, potential civil rights claims, professional accountability in certain circumstances, and those consequences are real and meaningful, but they operate after the fact. Your job in the moment is not to prevent the entry through argument or physical resistance. Your job is to preserve the record, through your statements, through what you do and don't consent to, through your observations, through your documentation afterward, that makes those after-the-fact consequences accessible and applicable. This is, in a way, the hardest part of this entire conversation to sit with, because it requires accepting that your rights in the moment of highest stress are sometimes best protected through a kind of restraint and patience that runs against every instinct telling you to fight back, to push back, to insist in real time that what's happening is wrong. The insistence that it was wrong belongs in a courtroom, with your attorney, in front of a judge, where it can actually result in something. The door of your home, with officers on the other side of it, is not that place, even when what they're doing is genuinely, clearly unlawful. Let's talk about the longer arc of this area of law, because it's actively developing, and developments in the years following Lang will continue to shape exactly where the lines fall. The Supreme Court did not in Lang resolve every question about when exigent circumstances justify misdemeanor pursuit into a home. It resolved the categorical question: no, hot pursuit of a misdemeanor is not automatically sufficient, but the case-by-case analysis of specific situations will be worked out in courts across the country over years and decades, as specific facts get presented and specific judges make specific findings that are then appealed and refined. Staying aware of how this develops, particularly in your specific state, is genuinely useful if this is an area of law that matters to your life or to the work you do. Let's bring the full picture back together, because I want to close with a clear, structured summary that gives you something concrete to hold on to, rather than a general impression of complexity that doesn't translate into anything useful under pressure. The rule, stated simply: hot pursuit of a misdemeanor suspect does not automatically give law enforcement the right to follow that person into their home without a warrant. That was the holding of Lang versus California, decided unanimously by the Supreme Court in 2021, and it reflects the deeper principle that the home carries the strongest Fourth Amendment protection of any space you're likely to occupy, and that warrant requirement protects that space most completely. What can justify entry without a warrant is genuine exigent circumstances, a specific, concrete, immediate emergency that cannot accommodate the time required to obtain judicial authorization, not the fact that a pursuit was underway, not the inconvenience of the process, not the passage of time, an actual emergency with real, specific, identifiable facts supporting it. What you do with that information in a real moment looks like this. You stay calm. You get inside if you can do so safely. You keep the door closed. You ask through the door whether there's a warrant. You state clearly that you do not consent to entry if there isn't one. You do not physically resist if officers proceed to enter anyway. You observe and document everything you can, and you get to an attorney as quickly as possible after the encounter is over. 4 sentences to carry with you, the same 4 sentences that apply across all of these situations. Do you have a warrant? I don't consent to you entering my home. I don't consent to this search, but I understand you have a warrant, and I won't physically interfere with executing it. I'd rather not answer any questions right now. Those 4 sentences, delivered calmly, respectfully, through a door you haven't opened, protect more of your legal position in more scenarios than almost anything else you could do in the same moment. Your home is the place the law protects most fiercely. A pursuit doesn't automatically dissolve that protection. A misdemeanor doesn't automatically dissolve that protection. What your door represents, legally, is a line that requires specific, meaningful justification to cross, judicial authorization in the form of a warrant, or a genuine emergency that couldn't accommodate that process. Neither the fact that officers were running after you, nor the fact that they want to continue what was started on the street is, by itself, that justification. Lang made that clear. The history of the Fourth Amendment made it clear long before Lang arrived to restate it, and now it's clear for you too, sitting here now, in advance, before you ever need it. That's exactly where this kind of preparation belongs, now in the calm, when there's no pressure, no adrenaline, no knock at the door. The version of you that handles this correctly is the version who thought it through before it happened, not the one improvising at the worst possible moment. And the version of you that knows the difference between a categorical rule that doesn't exist and the nuanced, fact-specific analysis that does, that version is in a significantly better position than the one who assumed the law was simpler than it actually is. If what we covered today filled in something that was vague or uncertain for you before, subscribe right now, because there's more of this coming. Real scenarios, clear explanations, the kind of preparation that turns a high-pressure moment into something you can navigate calmly, instead of something that catches you completely off guard. Know where the line is, know what crosses it, know what your door actually means, because it means more than most people realize, and it will keep meaning it as long as you know it's yours to protect. All right, that's where we'll leave it for today. I hope this gave you something genuinely useful, not just interesting to hear, but something you could actually use if the right situation ever came up. That's always the real goal here, understanding you can actually carry with you, not just information you forget by tomorrow. Take care of yourself, know what's actually yours, and I'll see you in the next one.